Please rise. The Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the Appellate Division draw near. Give your attendance and you shall be heard. Please be seated.
Good afternoon. Welcome to the interns and summer associates who are here today. We have a smaller calendar than usual, but that might be a good thing. I ask for the time that you need, not the time that you wish. There is more than 3 hours of argument time requested, and we are familiar with the briefs and the records. People versus Wallace. Appellant?
Appellant 4-1.
Respondent? 4, 1, and 3. The second case, Cheryl versus Iggy, I don't think that the appellant is here. I will call it again at the end of the calendar. People versus Katon, appellant?
Appellant requests 6 and 2, Your Honor.
Respondent?
Respondent requests 5.
6, 1, and 5. People versus Eddie is submitted. State Division Human Rights versus C&A Central, appellant?
Appellant, 3 minutes.
Okay, you want to argue it?
Yeah.
Okay, 3 minutes. J. Carey Smith versus 11 West 12th Realty. I know there's a number of parties here on this one. Plaintiff appellant?
Appellant, 8 and 3.
QRS?
QRS, I'll be asking for 5, 4.
Old House?
2 minutes, please, Your Honor.
Arrow?
I'm sorry?
Arrow?
Oh, my apologies. 1 to 2 minutes, Your Honor.
Ace?
Here, Your Honor. Nuo Jang from Katon and Sketcher, 1 to 2 minutes.
YS Electric?
1 to 2 minutes.
And probably this should have gone first, but I did it in order of the briefs where I got them. 11 West 12th Realty, Icon?
3 minutes.
3 minutes? Okay. Plaintiff appellant will get 7-1. If we need more time, we'll keep asking you questions. QRS will get 4, Old House 2, Arrow 1, Ace 1, YS Electric 1, 11 West 12 Realty will get 3. People versus DeLeon, appellant? That is submitted. Alcon Harbor versus Assurant Group, appellant?
Respondent, Your Honor.
Do you wish to argue without the appellant here?
I do not, Your Honor.
Okay, it is submitted. People versus Taylor? Submitted. And Gatak versus McKinsey is submitted. 1240 El Grant Highway is submitted. I know that the appellant is not yet here, and Cheryl, but if she comes while we're still having oral argument, I will allow her to argue. So just let me know if that occurs. Okay. So our first case on for argument today is People versus Wallace.
Step up.
Good afternoon, Nyla Siddiqui on behalf of Nicholas Wallace. Nicholas Wallace was denied his fundamental right to due process and effective assistance of counsel because he was never given the opportunity to review whether or not the search warrant issued in this case was valid. These traditional concepts are fundamental to our adversarial system.
Counsel, didn't we already decide in this case that we declined to or denied defendant's motion to unseal these materials? So why should we at this point revisit that determination which was made in 2016?
In 2016, when
Denied the motion to unseal the materials.
Well, because now time has passed, circumstances have potentially changed, and the principles under Castillo, where an appellant or a defendant should be afforded an opportunity to participate in his defense. And so in Castillo, they laid out a 4-step process where So at that time, that was denied because the prosecution presented safety concerns, which were relevant at that time, and disclosure wasn't necessary. Now, on appeal, we've moved to redact the search warrant so that we can review to provide effective assistance of appellate counsel.
There are many cases where we review the search warrants in camera and make a determination without disclosing them. Why shouldn't that be the case in this particular proceeding?
Because
I mean, we have the chance to review them, and determine whether or not they support the search warrant.
yes, and judicial review of search warrants is given a presumption of validity. And in our adversarial system, my client's right to review these to question whether or not they were to raise constitutional challenges, issues of staleness, particularity, and whether or not the search warrant is facially perjurious. Your review is based solely on what the prosecution has presented to you without critically evaluating Mr. Wallace's version of the facts, whether or not he was present, if this is a search warrant based on, say, an observation sale or a controlled buy, where there's a confidential informant saying he purchased drugs resulting in a search warrant, whether or not Mr. Wallace was even present on that day, present in the Bronx, any of those things would be relevant to determine whether or not the search warrant on its face was facially perjurious, whether or not it was stale, any of those things.
But wait, counsel, let me just, what's different now than when the first time we looked at this? You still haven't answered that. You said, oh yeah, there's more law, but.
It's not that there's more law. What's changed now is Mr. Wallace has filed a notice of appeal, has been given an opportunity to review his case, whether or not there's any issues. And back then, when the prosecution had said there are safety concerns, the question before the court now, when we file the motion for the search warrant, is it should be unredacted unless they present a reason where the safety concerns are still necessary. So what's different now
So
is...
you're saying that years later, someone can go back and make 10 years later, say, well, the CI's information is no longer relevant. I should be able to go back now, unseal, and even though the appellate division 10 years ago looked at the information, or even, I think in this case, much less, I should be able to now unseal it because it's been 10 years since the CI?
No, that's not what I'm saying.
Well, what are you saying?
If someone has a pending appeal...
One second. You were just said that the first time around, it was the safety of the CI that was paramount, right?
Yes.
And you're saying that's no longer an issue.
Yes.
So I'm asking you, isn't that generally true in any case, 10 years later, that there may or may not be concerns about the CI, so that anyone could go back and do that?
Well, yes, if there is
Okay.
a search warrant, that is effective assistance of appellate counsel. If the basis for a conviction is a search warrant, a person accused and even convicted of a crime should have an opportunity on appeal when they file their notice of appeal and have a counsel to review that to see whether or not it was probable cause.
Counsel, I'd like to ask you a question. Now, if the court finds that the waiver of appeal is valid, certainly there is no challenge, right, to the search warrant.
That would be true. However, in this case, we do not believe that the waiver is valid. The courts.
But if it was, you'll be out of luck.
If it was, yes, it would
I'm going to
not
let you address that on rebuttal, whether or not it's
Okay, thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Aiden Sanchez for the people. Your Honors, the lower court properly issued a protective order for the search warrant and its materials. The lower court reviewed in camera.
Why shouldn't we allow it now? There's been so many years that have passed. It's not the same concern or issues now that there would have been closer to the incident. Why shouldn't the court allow it to be turned over?
Yes, Your Honor, because at the time that the people moved for a protective order and the court issued it, that's a forward-looking decision because it looks to the potential future safety of the confidential informant.
Is there any way for us to know this down the road, whether or not, maybe the CI is still a CI, right?
That is correct, Your Honor.
right? So there's really no way to know one way or the other whether the situation has changed.
That is correct, Your Honor. It's a forward-looking decision because there can be a multitude of different situations where a confidential informant could be in a continuing relationship with law enforcement, for example.
And the trial court's initial decision to issue the search warrant is reviewed on appeal, correct? And the defendant always has the ability to ask the appellate court to look at what the trial court did. So there's two layers to make sure that the defendant's due process rights were protected, not just one.
Correct, Your Honor. So the issuing court issues the warrant, and then the suppression court reviewed in camera the application, the search warrant, the interview with the confidential informant, and the detective. And yes, this court has reviewed the suppression court's ruling in October of last year.
And we had the unredacted material, correct?
We have not provided it, but we have offered it to this
Right,
court.
right, right.
and
Okay.
Still are
Right.
willing to offer it.
Right.
Counsel, can you address the waiver of appeal?
Yes, Your Honor. So the waiver of appeal in this case was valid. During the plea colloquy, the court distinguished between the defendant's trial rights and his appellate rights, and explained what those two groups of rights meant. The court also ensured that the defendant's counsel had explained the right to appeal to defendant, and that the counsel and defendant reviewed the written waiver as well.
Did the written waiver contain anything that was left out of the original oral colloquy?
It did, Your Honor. The oral colloquy, the court explained what the right to appeal meant. However, the written waiver then supplemented the court's oral colloquy and explained that there were certain rights that did remain despite the waiver, and that defendant would be entitled to counsel for those potential claims.
Thank you.
Thank you.
Very quickly, there is a way to know whether or not there are continuing safety concerns or whether or not the confidential informant is still working with the NYPD by responding to this court in my motion and explaining those concerns. Instead, they're relying on safety concerns that were relevant over 6 years ago. And so there is a way to know, and since this court has not reviewed the search warrant materials in this case, we would ask it be remanded, allow defense counsel to review it, to look for whether or not the search warrant was
But we
found.
just looked at this issue last year, right? On a motion.
On a motion, but Your Honors did not the unredacted search warrant was not reviewed.
Okay, but still you haven't, what happened between the motion last year and this that
The motion was denied, and now,
Right. So my question, if you let me get it out, is what happened between last year and this year that would make us want to revisit that decision from last year?
Well, that the motion was simply asking for the unredacted search warrant. I am now explaining that failure to turn over the unredacted denies Mr. Wallace due process.
And you didn't.
And effective assistance of counsel.
Thank you very much.
Very quickly, the waiver?
What?
The
No,
waiver?
your time's up now, so thank you. People versus Keaton?
Good afternoon. May it please the court. Rosemary Herbert, Office of the Appellate Defender, on behalf of Eric Keaton. The police lacked probable cause to arrest Mr. Keaton where no officer observed Mr. Keaton exchange drugs, exchange currency, or even exchange any object with another person. Accordingly, Mr. Keaton's motion to suppress should have been granted. Now, at the suppression hearing, 3 officers testified. 2 of them acknowledged that they had no information that Mr. Keaton had done anything. They merely observed him standing outside of the Port Authority. Detective Varian, the 3rd witness at the hearing, claimed to have seen only a very brief hand touch between Mr. Keaton and another person purportedly involved in the sale. This occurred in the vestibule area of the Port Authority. Detective Varian did not see any object, he did not see an exchange of currency, he did not see anything that would make out the telltale signs of a drug transaction. And based on that very limited observation, there simply was not probable cause to believe that Mr. Katon had any connection to the subsequent drug transaction involving the undercover officer. At its core, what this case amounts to is guilt by association. The fact that Mr. Katon was observed in the presence of the undercover officer and two other men who apparently were involved in a transaction does not provide probable cause to believe that he was involved in this sale, and to do so would run afoul of those bedrock principles of guilt by association. Now, respondent has argued that the court must consider the broader context in which that very limited observation of the hand touch occurred, but that context does not provide probable cause. It's simply, the officer simply recounted that the undercover officer met up with another person, walked north a number of blocks, shortly before arriving at the Port Authority, met up with Mr. Katon and a third person. Mr. Katon and the third person then separated, went into the Port Authority. There's this brief observation of a hand touch, and then Mr. Katon left the scene. He headed northbound. He is not present at the time of the interaction that leads the undercover officer to make a positive buy sign. And under those circumstances, there simply was not probable cause to believe that Mr. Katon had any involvement. So whether you consider the limited observations of Detective Varian or the broader context, there is not probable cause. And a contrary ruling would greatly extend any prior authority that has required observation of telltale signs of a drug transaction and would essentially give to the undercover officer who provides the buy sign the ability to determine probable cause. And that's certainly not what the Fourth Amendment or the state constitution permit. If there are no further questions, we'd rely on our brief and ask that the motion to suppress be granted.
Thank you.
Sarah Lubin for the People. Officers had probable cause to arrest defendant for his participation in the charged drug sale. Because of the participation of an undercover, officers had conclusive evidence that a drug sale had occurred in this case, and the totality of the circumstances leading up to that drug sale gave officers probable cause to believe the defendant had been a participant in that sale. And the sequence of events in this case is important to that probable cause determination. Detective Varian testified that initially the undercover officer met up with an individual who's referred to throughout the hearing as J.D. Black at the Penn Station outside of Penn Station. After those two individuals engaged in conversation, they then traveled to Port Authority by foot and went directly to defendant and J.D. Blue. J.D. Blue, defendant, J.D. Black, and the undercover officer then engaged in a brief conversation while walking 1 block south. As soon as they arrived 1 block south,
Was counsel correct that the only physical interaction that was observed was a slight hand touch and that was just not enough?
That is correct, that the detective testifies that he observed a brief touching of hands. However, it is that exact same language that he also uses to describe the exchange between J.D. Blue and the undercover officer, which we do know was an exchange of narcotics because of the positive buy sign that was given. So that same language was used to describe both instances.
And that was enough to provide probable cause for the stopping and arrest of this defendant?
Yes, given that immediately after seeing defendant and J.D. Blue touch hands in the Port Authority vestibule, J.D. Blue then immediately goes back outside and approaches the undercover officer and J.D. Black and completes that transaction that we do know occurred because of the presence of an undercover. So all of these factors, when considered together, are what gave officers probable cause in this case to believe that a narcotic sale had occurred. If there's no further questions, we'll rely on our briefs. Thank you.
Thank you very much.
Very briefly, Your Honors, there is certainly no question here that there was probable cause to believe that a sale had occurred. The question is, was there probable cause to believe that Mr. Keton was involved in that sale? And respondent sort of analogizes the hand-touching that was observed between J.D. Blue and the undercover officer and the one that was observed earlier. But the significance is, there you have confirmation from the undercover immediately after. Here, we don't know what this hand-touching signified. It could have been a meeting.
Are we permitted by the cases to take a look at the entire, look at it like in the totality and determine that there was probable cause?
Of course, the court is permitted to look at the totality of the circumstances, but here the totality of the circumstances simply do not establish probable cause as to Mr. Keton.
Counsel, let me ask you, did Mr. Keton have the buy and bust money?
He did. That was not recovered until afterwards. That
Right,
says
right.
nothing about whether there was probable cause at the moment that he was arrested in the Port Authority.
But they see these two things. I mean, this all happens in a couple of minutes. It's not like 3 hours go by where he can go and buy something, right? A couple of minutes, they see hands touch, then hands touch again, then they immediately arrest him and he has the buy and bust money on him, right?
Right. The fact that pre-recorded money is recovered subsequently cannot factor into the
100% agree,
probable
but
cause.
the idea, but you are saying that there is only just a slight touch, right? But the slight touch and then the slight touch go from him to the person who hands the drugs to the undercover,
Well,
right?
again, to
And we're
assume-
talking just a couple of minutes. This is not a 3-hour transaction.
Absolutely, Your Honor. The
Right.
time frame, I don't believe there's specific testimony about the lapse of time, but it is certainly a small amount of time. But the difference between the second hand touch is that you have confirmation by the undercover officer. Here, we don't know. It would be speculation to say that the very brief physical contact is somehow a transfer of drugs or a receipt of money connected to that sale. And we simply can't say that based on the fact that there's no object of any kind observed, no currency. There simply is not an exchange, and that is what is required under this court's precedent and those from the Court of Appeals.
Thank you very much.
Thank you.
State Division of Human Rights versus CNA Central.
Good afternoon. May it please the court. My name is Michael Swirsky. I represent the New York State Division of Human Rights. And our agency is asking this court to confirm our order after hearing, finding a broker and an agent liable for denying its services to the complainant because of his source of income. In 2019, the legislature added source of income as a protected class in housing discrimination under the state human rights law, recognized the need of a vulnerable population for access to housing that they might not have otherwise.
We've actually had prior cases involving this very provision.
I believe that this is the first under the state human rights law. There have been others under the city human rights law that this court has dealt with, and it is.
Is there any difference between the two in terms of how we should approach them?
Not at all. And in this particular case, of course, a human rights law of the state and the city forbid a real estate agent or broker from refusing its services to a person because of their source of income. And this case involves undisputed evidence that when the complainant calls CNA Central Realty to inquire about renting an apartment, he was first told there were plenty of apartments available, and then upon the realtor's inquiry, when he revealed that he was a person with disabilities who had a Section 8 voucher, the tone changed. Well, some of our landlords don't allow Section 8 vouchers, and realtor advised him to seek other options and never got back to him.
Counsel, is there any issue with regard to potential service here? Because they haven't responded.
We serve them, we serve the respondent through the Secretary of State. They seem to be an entity that has a business in the Bronx, and the process server was told that A.D. Lantigua, the individual agent, worked there when he came to serve the papers. So I presume that they received the papers and didn't respond. They didn't respond to
The hearing either.
yeah, they're in default. And our agency awarded damages for mental anguish and a civil fine and assessed a civil fine and penalty. If there are no further questions, I will rely on my brief.
Thank you very much.
Thank you.
You, Cheryl?
Yes, hi.
Come on up.
Good afternoon, Your Honors. If it pleases the court.
Okay, you weren't here for the call of the calendar, but I'm going to give you 3 minutes to present your arguments.
I thought I had 15.
What?
Thought I had 15 minutes.
15 is what you requested, but the court makes a determination, and you have 3.
I'm sorry?
15 is what you requested, but the court makes a determination. No one actually gets 15. You weren't here for the call of the calendar. You'd see many people.
So there's
much
not
less
really
time.
anything I
You have
can do
3
with 3
minutes.
minutes.
You should begin, because your time's going. So tell us your argument.
All right.
I'll
gonna
actually
take me
start
more
the
than 3
clock
minutes
again to
just
3. Go ahead.
It's going to take me more than 3 minutes just to get my, get to the computer.
Go ahead.
Right, so,
Begin.
okay. All right. Hold on, if you can just let me find the document. Hold on. Okay. Hold on, I'm sorry. Clear. All right. All right, let me just speak. Police is the court. My name is Cheryl Uzamire. My request is for spousal support from Iggy Uzamire. There's been a lot of corruption as a result of during the course of my trying to litigate for spousal support. There should not have been, because there are only 2 issues that should concern the court. The first one has to do with application of CPLR 5015 that gives a person who defaults, a litigant that defaults, the opportunity to vacate the dismissal or vacate the decision for good reason. When family court granted us spousal support, interim spousal support, they gave my husband 35 days to respond. He didn't. When his attorney, the court granted it on March 31st of 2021. His attorney did not respond didn't make an appearance until May 27th. CPLR 5015 is clear. 30 days, 35 days if it's mailed. He did not respond. There should not be any other question regarding the fact that he did not respond. On the interim order of spousal support, there's a paper at the bottom, there's a message at the bottom that says that basically the only way in order to vacate, in order to get rid of the decision, is via vacating. And the only way to vacate, based upon what I know, is CPLR 5015, vacate for good excuse. The other issue has to do with my husband's identity. My husband is an immigrant, he's a citizen now, but he's an immigrant. Since 2007, 2008, the entire court system has illegally attempted to litigate the issue of my husband's identity. There are no courts anywhere in the United States, whether it's with a state or with the federal government, who has the right to litigate the issue or to litigate the issue to determine any person's birth identity.
I'm going to give you 2 more minutes.
Thank you. Birth identity is a function of the executive branch of the government. Person that's born, let's say a U.S. citizen, that's born in the United States, their birth identity is determined by the Department of Health in the state in which they live. Where immigrants are concerned, a person's birth identity is determined by the United States Citizen and Citizenship Services, used to be called Immigration and Naturalization Service. Now what's the United States Citizenship and Immigration Service, it works as a Department of Health. It asks for birth identities. It asks for, birth identities. It asks for medical information. The judicial branch of any government does not have the right to determine birth identity. That's a responsibility for the state. Now, at the time that I presented my documentation to the court, I gave the court information from the United States Citizenship and Immigration Services. First, I gave them information from Rachel McCarthy. She was she's the former bar counsel for the United States Citizenship and Immigration Service. I received that information because at the time I had some problems getting information. I made a number of phone calls to her office. She and the U.S. Attorney, Eugenia Cowles, engaged in malicious misconduct.
Just so you know, you only have 30 seconds, so you need to wrap up.
All right, does that 30 seconds include your saying something to me?
Go ahead.
Thank you. Rachel McCarthy and you interrupted me. Rachel McCarthy and the attorney Eugenia Cowles that engaged in malicious prosecution by charging me with assaulting her, something I could not have done because at the time of the incident, she was in Burlington, Vermont, and I was in Brooklyn, New York, so I could not have assaulted her.
Okay, we have your papers. We're going to thoroughly read your papers, but your time for argument is over at this
All right, but you've interrupted me a number of
And I
times,
gave
ma'am.
Counsel,
You've
I
interrupted me
gave
a
you
number
extra
of times.
time.
You've interrupted me a number of times.
I gave you
May
extra
please finish?
time.
You interrupt. I did not get 3 minutes because you've interrupted me
Counsel,
several
I
times.
gave you- I
Are you
gave
Cynthia Kern?
Yes, I
All right,
gave you
just letting you
5
know
minutes.
also that I've already filed, one, I have a lawsuit that is now pending, an appeal that's now pending, excuse me.
Officers.
It's an appeal that's now pending before the United States Court of Appeal, and I'm in the process of filing a lawsuit against you. It'll be filed by the end of the day.
Thank you.
You should watch making a decision, because you all are now litigants in my lawsuit, federal lawsuit.
J. Carey Smith versus 11 West 12th Realty. What? You can argue whatever order you want to argue, whatever makes most sense for you. I'll leave it to you. Go ahead.
Good afternoon, Your Honors. My name is Ahmed Kassim. I'm counsel for plaintiff appellants, the buyers in this action. This case is about active concealment of defects in a $20 million townhouse.
So what about the fact that the contract had pretty strong disclaimers that you were taking it as is? How do we deal with that in the case law from Danan from the Court of Appeals? I may be pronouncing that case wrong.
Sure. The disclaimers do not immunize the seller and the contractor defendants from breach of contract or fraud claims. This was decided by this court very similarly. This case, as is, and no representation disclaimers were found in TIA Global.
Okay, so the two big cases here are Danon and TIAA, but weren't there, and Danon said it was an absolute disclaimers, there were no exceptions, but in TIAA, there were carve-outs to the exceptions. So why should we not follow Danon versus TIAA, where TIAA did have the carve-outs, which Danon didn't have, in this case doesn't have? Because this case has no carve-outs. It's absolute, as is, no exceptions, no nothing.
Well, if you look at paragraph 12 of the contract, just to get to your point about the disclaimers and how Dan could be distinguished, on paragraph 12 of the contract, there is a lawyer's notation that says, as is, comma, except as set forth herein. And that sort of qualification and
But
carve
are
out.
there any actual exceptions carved out in the actual contract to the as-is language? I mean, I looked very carefully. I didn't see anything in the contract in this case that had any carve-outs to the as-is language. In fact, it just kept being emphasized in different ways throughout the contract, reaffirming the as-is language, unlike the TIA case, which did have carve-outs.
Right, so in this case, we think the conditions of closings are the exceptions to the as-is.
The law is very clear that conditions to closing do not survive the closing. So to the extent that you're relying on any of the conditions to closing, it's black letter law that those don't survive. So is there anything other than the conditions to closing that you can point to in the contract that create any type of carve-out to the as-is, no liability, no representations, concealed, not concealed?
The problem that the conditions to closing are the question. The idea that we argue in our briefs about the conditions to closing is that they were actively concealed. There was a misrepresentation.
But I'm repeating myself, but the conditions to closing don't survive the closing. So you'd have to point to something other than the conditions to closing to support a claim that there's some carve-out to that as-is language.
Well, we believe that active concealment gets us by the conditions to closing.
No, how? In what way?
Because
what are you alleging is the fraud?
Sure, the fraud is one. The townhouse was renovated poorly, and the nature of the defects, unconnected piping.
So how do you get around with, let me just interrupt you for 1 second. Purchaser specifically acknowledges that seller shall bear no liability for latent or patent defects. I mean, this is not two people who have unequal bargaining power. You could have taken that out. You could have said, I don't agree with that. You could have done, and this is a $20 million sale, heavily negotiated contract between two parties. If you say, I agree that you, seller, bear no responsibility for patent or latent defects, and what you're literally saying is there was a latent defect that I didn't know about. Well, you said in your contract that you are disclaiming that. So I don't know how you can avoid that.
Here's how I avoid it. A latent defect is I go into your house, I look in the basement, and I don't see any issue of, I inspect the basement, I buy the house, I come to find out that the basement was built on bad soil. I can't sue the seller for that.
Counsel,
I go into your basement.
Here you're talking about,
you're
talking about HVACs. Those are all things that.
But once, yes. So, but I go into your house and I find that that you've covered up cracks in the foundation, and you've told me expressly that the basement is fine. And then when I buy the house, I find out that you covered it up. That's why this case is about active concealment.
That you just distinguished your own example, because you said, you told me everything was fine. If there was a representation that everything in the house is perfect and everything works perfectly, you would have a great case. The problem, and I'm going to go back to the very first question I asked you, which is why isn't this case identical in its facts to Dannon? In Dannon, there were no carve-outs or exceptions to the as-is language, unlike TIAA. Why isn't this case controlled by Dannon, which has pretty much identical language in the contract to the language in Dannon, which said you can't rely on fraud where there's a specific disclaimer, i.e., we're not making any representations as to latent or
and here's how I distinguish Dannon and how I don't distinguish my own case. When the contract, those cases happened before the contract was signed. The representations were made prior to the contract. At least the best I can tell about Dannon, it seems the representations were made prior to the contract. We allege in the complaint that the representation was made after we signed the contract, that all of the conditions to closing were corrected. And we relied on that representation prior to closing that the
That
seller.
takes you right back to the law about closing conditions don't survive the sale.
Yeah, but
Your remedy is not to close.
But we can't, if the remedy is not to close, if we hadn't inspected and we didn't know that there was no conditions to, and we didn't take efforts to determine if the conditions to closing had been met. But saying that we can't close because we were actively, the conditions to closings were actively concealed, then we have fraud, and that's an exception to the as-is disclaimers. That's an exception to the brief, and that's an exception for us to bring up breach of contract.
Your time's up for now.
Yes.
There's a lot of other people arguing. I'll give you extra time if needed in your rebuttal to respond to some of those arguments if need be. Just let me know in advance, because I know you're not going in order, and I gave everyone different time. So who you represent? Go ahead.
The seller entities, 11 West 12th Realty, Icon Realty, Terrence Lohenberg, and Todd Cohen.
Okay.
So how do you respond to that argument that this yes, yes, the buyer represented,
Right.
they did their own inspection, that they weren't relying on any warranties or representations, that they agreed that the seller would not be responsible for any patent or latent defects, and yet somehow or another there's going to be a fraud claim. How do you respond to that because there was an active concealment of conditions to close?
There is no specific allegation of active concealment, just a conclusory statement, this is actively concealed. There's no explanation of that. It also doesn't make sense when you look at the things that were...
Counsel, why isn't this case controlled by TIAA, where the court said, we look to the special relationship doctrine, they're clearly making allegations that things were hidden, that there were, fake fixtures that didn't have anything behind them, and that they didn't have the ability to discover that until after the closing. Why isn't TIAA controlling?
For the reasons you mentioned earlier, there's no carve-out in the agreement, and because these particular defects that are mentioned are really not of the type that can be concealed. A leaking HVAC system, that's not the type of concealed behind walls, something that's not discoverable. They had an inspector come in, they say it in their papers, and inspect. A leaky
But they couldn't, they didn't do any destructive testing, opening up the walls. There were some problems that they determined with the roof not having been put on correctly. I mean, those were things that there would have needed destructive testing for.
Well, no, the roof leak was actually
More
discovered.
than, it was that it was used.
It was discovered by the inspector. That was, they didn't need any destructive, they inspected it and found the leak.
So is there option then not to close if
That's
they
right.
want to close? So you're saying they discovered the leaks before the closing even occurred?
I think the roof is the primary issue here, because I think that was the most expensive fix. And they discovered that leak. There was a repair, but maybe it wasn't a good repair, but that's the whole point of those conditions to closing.
Is there any argument to be made on their part, though, that the right of inspection did not allow them to do the kind of inspection they needed to do to discover these kind of defects?
So the case law is, there is an exception where if you could never discover it. If you said the house is all, there's insulation, it's a completely insulated house, and you'd have to tear down the walls to figure that out, and it turns out it wasn't, that could be fraud. That is not what's here.
So what is here? There's the roof. What else is here?
An HVAC, there was a nail in a pipe. I mean, they were concealing that. That's construction. There's absolutely nothing here that's...
Counsel, just to go back,
Sure.
because the inspector, I believe that was Old House, did the inspection and indicated that the pre-closing conditions were corrected. The plaintiff alleges that in the complaint, correct?
And let me just say, wouldn't that be covered by, and I agree, I specifically acknowledge, even like if that the seller has nothing for latent or patent defects.
Right.
And the buyer could have taken that out and said, I haven't had the opportunity to tear down the walls, so I'm not going to agree to that, correct? There was nothing that was
These are
put in
literally
the
latent
contract,
defects.
right?
Exactly what they said they would not have liability for in this contract.
And there was nothing stopping, and this is a negotiated contract between parties, right? Okay.
Thank you very much.
Thank you.
My name is Scott Benjamin from the law offices of Andres Vacilados. We represent one of the defendant respondents, QRS, which was a general contractor in connection with this project. And I want to largely rely on our briefs and submissions and the arguments by counsel who spoke before. The unique argument that we had particularly raised below was the argument of capacity to sue. So I just thought I'd take a few moments if the court has any questions about that. The essence of our position, which we believe that the court below.
If we reach that issue, why can't they just amend them? Why can't we give them leave to amend to put the right party in? I don't see how that really stops the lawsuit from going forward.
Your Honor, all of the cases that plaintiff appellant cited in connection with the ability to amend were all cases in which either the defect had been waived or were cases in which the party did the amendment prior to the time they got here.
You're saying we don't have the authority to allow them to amend if we find that that's...
I think at this point, no, because the case has been dismissed. They could possibly refile with the proper parties, but when we made the initial motion, they could have, at that time, made a cross motion to amend. Instead of doing that, they very defiantly and steadfastly said, no, we don't have to.
Well, it's not like they're strangers to the transaction here. I mean, they were trusts in their name, and it was the individuals who were the trustees who were acting upon. I mean, a trust is not a person, so you need a person to act upon that. So what's the problem?
The law is very clear that a trust is a legal fiction that does not have the capacity.
I understand that.
And a trustee, and if anybody should know that, it's the trustees themselves, because if the court, if your honors look at the deed that's at page 192 in the record, the deed was actually changed by hand, presumably at the time of the closing, from the J. Carey Smith Trust to as trustee of the J. Carey Smith Trust. So that was actually written in by hand, so if anybody should have known how to identify the proper party, and I would argue that this actually gets into an area that's closer to standing than capacity, because it is the trustee that actually owns the property. So if there's anybody who is suffering damage or who's suffering harm, it is the trustee, not the trust, because the trust is essentially a piece of paper, a contract. That's why the trust can't bring suit in the name of the trust. I did want to point out that in their reply papers, they had cited to a number of cases, which unfortunately in the structure of things I don't get to respond to the reply, but each and every one of the cases that they cited to are all cases in which the question of capacity or the question of standing had been waived. And obviously there are a lot of defenses that can be waived, but that doesn't mean the defense doesn't exist if a defendant chooses to assert it. I would also point out that in a footnote 3 in their appellant's brief, they drop a footnote talking about the way in which the court below had conflated standing and capacity. And I just wanted to refer this court to a case called In Re Part 60 RMBS. It's cited as 155 AD 3rd 482, in which this court, in fact, Your Honor, Justice Kern, stated that we courts conflate those terms all the time, but that's not an infirmity, so that there's no defect in the court below's decision. We believe the court below got it correct in connection with the capacity/standing argument, as well as the more substantive arguments.
Thank you very much.
Thank you.
Good afternoon, Your Honors. My name is Nuo Zhang, here for Ace Solutions in this matter. I think my co-appellee counsel has raised some excellent points, to which I will say that our arguments will incorporate the arguments raised by my co-appellees today. And to which I would like to add that there are a number of parties here today which are situated in a similar position as Ace Solutions, in that they do not have direct privity with the plaintiffs in this matter, and the only privity they've had at any relevant time in this matter is with QRS, which was the
Do you
general.
want to address the fraud issue too? Why there can't be a viable fraud claim against?
Yes, Your Honor. We believe that the Supreme Court acted properly in dismissing the fraudulent inducement, the fraudulent concealment, and the unjust enrichment counts because they were not properly pled. They were not pled to the required standards under the CPLR, which carries a heightened specificity in fraud-related matters. Fraud is supposed to be pleaded with extreme specificity as to the individuals and the fraudulent acts alleged.
I thought you were going to make, your time's up, but I thought you were going to make the argument that there were no representations made by your client, but go, maybe one of the other parties will make that, so, okay, thank you.
Thank you.
Good afternoon, Your Honors. Farzad Ramin for the respondent, YS Electric. We were one of the subcontractors on this townhome renovation. Even if appellants can get past the fact that they were sophisticated parties represented by counsel throughout, hired inspection companies, and still left that as-is language in the contract, we argue they didn't plead any of the elements for the 4 causes of action that they brought against us. The fraudulent concealment, it's well settled you need some sort of confidential duty or relationship, some sort of privity between the parties. In our original motion to dismiss in the Supreme Court, my client submitted an affidavit. He had no idea who the appellants were. You know, they dealt with the general contractor. So there's no way that they could have misrepresented or concealed anything to them. And I think that lack of privity also goes to some of the other claims, such as the private nuisance claim, as well as the racketeering claim.
Thank you very much.
Good afternoon, Your Honors. My name is William Arsenault. I'm here for the respondent, excuse me, Aero Elevators. We will be adopting the arguments made by the co-respondents in this matter, as well as reliance upon the briefs. I would just add, as this was not previously discussed, General Business Law 777 was one of the other charges against our client, Aero Elevator. I would just note that, as was determined in the original Supreme Court argument, General Business Law 777 is only to apply for new homes, which this would not have been in this matter. Thank you so much for your time today.
Thank you.
Good afternoon. Cheryl Corman for Old House Inspection. First, I would just like to point out that the record on appeal was not complete. It didn't contain any of the opposition papers or reply papers, and really meaningful appellate review is not really apparent on the face of this record. And I think that the court could readily dismiss this appeal based upon the failure to produce an appropriate record. But were we to reach the merits of the case, the breach of contract claim against Old House was properly dismissed. There was the failure to abide by a condition precedent in the contract, that there was a requirement to give 72-hour notice before any of the repairs were undertaken. It's interesting that the arguments have morphed a bit, and now in the reply brief, for the first time, there's an argument raised that the condition precedent doesn't apply to any of the specific items that weren't inspected, so in a way to somehow change the argument, no longer relying on futility, but now raising a brand new argument on reply. I would just point the court to the actual contract between Old House and the plaintiffs,
which specifically says that there's absolutely no responsibility for any uninspected defective conditions or deficiencies. So even if we were going to look at the morphed argument, it's lied by the
And
actual.
didn't your contract actually at least state, I think it was a one-page contract?
One page, yes.
Limited any liability to $750?
Yes, that would be if there was any liability to be had to begin with, but we don't think we even get there because there should be no responsibility under the specific arguments here.
Aside from saying it was futile, was there any facts pled?
No,
So-
of course, it was just
Right?
a notice provision. We didn't say we wanted to stop it and make any of the repairs.
Right.
So it was really just a
So
notice provision.
and I think the buyer acknowledges they didn't comply with the condition precedent.
Yes, and-
And other than arguing futility, there weren't any facts pled to support any futility, correct?
Exactly, and I would just like to make one more point with Your Honor's permission. If you look at the specific report that was given, there are a lot of arguments that are raised as to specific items. Like, for example, there's a lot of reference to the potential issues with the roof. Well, there was, on the first inspection, a problem with the bulkhead. That was clearly repaired. That's not an issue. There are other problems with the roof, but if you look at page 227 of the record, the second inspection report specifically notes that there are issues with the roof. It is not a new roof, and that we couldn't estimate how much longer the roof life had, and that we specifically cannot rule out that leaks would occur. So while it's nice to point to different things that went wrong, I think if you carefully look at the inspection report, even though we had very clear language that we were not responsible for the issues, these issues were in fact noted in the second inspection report. Thank you very much.
Your Honors, given very quickly the limited time and the arguments raised, I do want to just talk a little bit about the defects. They're not minimal. These were unconnected pipes and unconnected systems hidden behind walls. The sump pump was never inspected, even though the inspector was in the boiler room and didn't test the sump pump.
Did the inspector say he tested the sump pump?
No, he did not, but he was in the boiler room, and it's an installed system. It's an
Right, so the
installed
question
system.
is, if he didn't say he inspected it and he didn't inspect it, what's the issue?
So this is the issue. We think that the reason the condition, we think the issue is that there were certain things that he inspected and he did wrong, and that there were certain things that he didn't do which he was supposed to inspect. He was supposed to inspect and in the installed systems. And the sump pump is a great example of an installed system that he did not inspect, which was in the mechanical boiler room.
But the thing is, if there was a way that you could have determined that there was a problem, then I don't know how you get past the as-is situation. I mean, that is dealing with the exceptions to Dinan that's pointed out in TIAA, or I might have gotten the initials wrong, but you know what I'm talking about. That allowed, if there were some latent defects, that there was just no way with reasonable intelligence you could have found it. But if you could have found it, then aren't you bound by, you should have found it or else you're out of luck?
There are many that we could not find. We could not find the unconnected plumbing systems behind closed walls, the air handler that was enclosed behind sheetrock.
So then why did you say why did you agree that the seller shouldn't be responsible for latent or patent defects?
Because I think there's a difference
if that was your point, then why would you agree to that?
We think there's a difference between an actively concealed defect and a latent defect that just exists without fraud.
It exists one way or the other, and you said, and then you literally said, the seller shall not be responsible for it. Whether or not you knew about it is irrelevant, or whether you agreed that you wouldn't be responsible for it, that the seller wouldn't be responsible for it. You didn't have to agree to that. This is a heavily litigated contract.
We believe that the fact that the latent defect was actively concealed is a difference.
Why? Why is that a difference?
Because that implicates
actively concealed in what way? It's behind a wall. It was going to be behind a wall, whether it was either way, whether there was mens rea or not. It's behind a wall. That is the definition of a latent defect.
Yeah.
Go ahead, Nancy.
it was behind the wall, unconnected to any other system.
Yeah, agreed, but
The
that's
reasonable
the
inference-
same latent defect, whether the mens rea is positive or not.
And I didn't get a chance to, I didn't get a chance to get to the other arguments on the record or the
We're familiar with the briefs and the record.
capacity, but I don't waive those arguments. I rely on my brief on those
Thank you
arguments.
very much.
Thank you very much, Your Honors.